Good afternoon and welcome to the White and Case World Championship match of the 65th edition of the Philip C. Jessup International Law Moot Court Competition. In a moment, our esteemed panel will enter the room. We'll do the usual all rise. I think you're all accustomed to that at that point. Before we do that, I need to ask everyone in the room to please check your phones, pagers, wireless faxes, laptops, autonomous aerial vehicles, anything else, and make sure that they are in silent mode. Take a moment. Make sure they're in silent mode. All right, I'd like to thank you. After almost 8 months, 642 teams, over 90 countries, thousands of memorials, tens of thousands of memorials and oral round grades, a week of incredible competition. It's come to this. I'd like to congratulate our two teams, and while the judges aren't here, our applicant, Universidad Torcuato de Tella from Argentina. And on behalf of Respondent from the Philippines, the University of the Philippines. With that, I will ask the bailiff to please bring in the court.
All rise. The International Court of Justice is now in session. President Infante Kafi and the Honorable Judges Menon and Yudkivska are presiding. The case before the court is the case concerning the Stern 40. The parties are applicant, the Republic of Antrano, and the respondent, the Kingdom of Remisia. The applicant and the respondent are each allocated 45 minutes to present their pleadings.
Is the applicant ready to take the floor? Please, take the floor.
Am I audible? Madam President, Your Excellencies, good afternoon. My name is González Colny, and along with my co-agent, Mr. Inaume Barbela, and our of counsel, Mr. Manuel Schmidt, it is an honor to appear before the International Court of Justice, pleading on behalf of the applicant, the Republic of Entrano. Over the course of the next 21 minutes, I will address the two first submissions for the applicant, which refers to Remisha's deprivation of nationality of the Student 40. I will address first Entrano's standing to bring this matter before this court, and second, Remisha's violations of international law when rendering this individual stateless. Then my co-agent will address the two last submissions for the applicant, and finally, we respectfully reserve 30 minutes for rebuttals. May it please the court. Your Excellencies, Entrano respectfully requests this court to consider what is at stake. This is a case in which one state, pursuing the interests of its own monarchs, has decided to ignore its human rights commitments, exposing its own citizens to unacceptable violations of international law. Regarding the facts, on November 2015, Misa Kisho, a Moldovan national, and the Prime Minister of Remisha signed an agreement creating a joint venture for increasing cobalt mining activities. 4 years later, when these activities already started, a group of students started to protest against the environmental hazard created by these activities. When the protests expanded all over the country, more than 1,000 students were detained by Remisha's authorities, 230 sentenced to imprisonment, and 40 of them, the Student 40, deprived of their remission and sole nationality.
Excuse me, agent, but you are referring to domestic facts that had taken place in a foreign country. How can you justify your interest and a legal interest in that respect?
Madam President, the first submission for the applicant refers to the legal interest in this matter, and it is the applicant's submission that it has a standing both on an erga omnes partes basis and on an erga omnes basis. It is the applicant's main submission that it has erga omnes partes standing to claim Remisha's violations of its conventional obligations, and that it has erga omnes standing to claim Remisha's violations of customary international law.
Is it your case that every obligation in a multilateral treaty is enforceable erga omnes partes?
No, Your Excellency. There are obligations under multilateral treaties which are not established towards the protection of a collective interest, or are established by one state toward another state and cannot be considered to be owed erga omnes partes. However, we submit that the obligations involving these proceedings meet every requirement that this court has established in order to be considered erga omnes partes. The rationale behind this notion can be traced back to 1951, when this court issued the advisory opinion on reservations to the Genocide Convention. In that decision, it was established that there are certain treaties in which parties do not have any interest of their own, but rather a common interest, being impossible to speak of individual advantages or disadvantages of the state. The main obligations in these treaties are established towards the protection.
What have been the type of rights that have attracted this kind of obligation, which is an obligation owed to all the parties? What have been the type of rights that have been recognized to have that status?
Your Excellency, to the moment, this court has accepted the erga omnes partes nature of the obligations established in the Genocide Convention, in Gambia versus Myanmar, for example, in the Torture Convention, in Belgium versus Senegal, and in the Convention on the Regulation of the Whaling, in the Whaling in the Antarctic decision. The factors that this court has considered relevant are those which are crystallized nowadays in Article 48(1)(a) of the 12 Articles on State Responsibility of the ALC. It is required that the obligation is established among a group of states for the protection of a collective interest. In its written submissions, the respondent has argued, and I quote, that the 1961 Convention and the International Covenant on Civil and Political Rights are multilateral treaties that do not create obligations that Remisha particularly owes Antrano. And we agree with this position. The obligations under these treaties are not owed specifically to Antrano, but to every state party of the treaty, and consequently, any of them may invoke their violation in any given case.
Agent, where do you find that kind of obligation in that treaty that dates back to 61?
Madam President, we submit that Article 8 of the 1961 Convention on the Reduction of Statelessness, or Article 9 of the treaty, are of an erga omnes partes nature. The collective interest, which enlightens this treaty, the reduction of statelessness, not only is present in the title of the treaty, but also in other elements that this court has considered relevant on this regard. According to the preamble, states parties have accepted its obligations, considering it desirable to reduce statelessness by international agreement. We shall not ignore that this is the exact same wording which is employed in the preamble of the Convention Against Torture, and that interpreted by this court in paragraph 68 of Belgium versus Senegal evidences every state party legal interest within compliance with this common objective.
The concern I have is that with certain types of conventions, such as those that you've mentioned, genocide, torture, environmental devastation, you can understand why there is a compelling interest to give a right to enforce to every party to a multilateral treaty. I wonder whether the same can be said about the problem of statelessness, given that the convention, the 1961 convention, does not impose an absolute prohibition. It recognizes that there are certain derogable situations. And I wonder whether in any of the examples that you have mentioned, there have similarly been derogations that are permitted under those treaties.
Your Excellency, I can see your concern on this regard. However, the previous judgments of this court on the matter do not contain any finding that limits the notion of erga omnes partes to the existence or not of exceptions.
They may not have limited it, but one can try to understand what the reason or rationale is behind it by looking at the facts and circumstances that were presented to the court in those cases.
On this regard, Your Excellency, we can provide example of the International Covenant on Civil and Political Rights of a treaty, which contains the possibility of derogations and is still of an erga omnes partes nature. This character of these obligations has been accepted by the Human Rights Committee as the chief interpretive body of the Covenant in General Comment number 31, as it was established by this court in paragraph 66 of the Amadou Sadio Diallo decision and paragraph 136 of the construction of a wall advisory opinion. The Human Rights Committee should be given great weight in the interpretation of the Covenant, so it should be persuasive to this court when resolving this case.
If I may add to Judge Mennon's question, of course, in certain times, deprivation of citizenship, like, for example, consider Nazi Germany, it might be the first step towards a genocide. Now, in this particular situation, in this case, how you can justify that deprivation of citizenship in this particular case might justify erga omnes obligations?
Your Excellency, thank you for your question. It is not the applicant's submission that the 1961 Convention is of an erga omnes partes nature because of a kind of gravity that can be assimilable to those that this court has established as erga omnes partes. In fact, the International Law Commission, when drafting the draft articles on state responsibility, it was discussed the possibility of making reference in Article 48 of the gravity to defense or even to peremptory rules of international law. However, this position did not survive the drafting committee of the International Law Commission because international tribunals do not consider the gravity of defense in order to determine whether it is established for the protection of the collective interest. We submit that since the obligations involving these proceedings amounts to every requirement that this court has established in this regard, this court should maintain the criteria adopted in the 2012 Belgium versus Senegal decision, the 2022 Gambia versus Myanmar preliminary objection decision, and only 2 months ago in the order for provisional measures in South Africa versus Israel, when it accepted that any state party to these treaties may invoke the responsibility of another state with a view to determining the alleged failure to comply with its erga omnes partes obligations. Finally, Your Excellencies, we respectfully request this court to consider what would happen if we do not accept erga omnes part standing in these proceedings. The violations of international law committed by the respondent affected essentially individuals, the Storm 40. Consequently, the only remaining source of standing would be diplomatic protection. However, diplomatic protection is based on the notion that only the state of nationality may invoke the responsibility of another state. And this is particularly problematic in a case in which international law is precisely violated by rendering the individual without a nationality. In other words, not accepting erga omnes partes nature of these obligations would simply mean two things. First, that states parties to the 1961 Convention incorporated a jurisdictional clause of impossible use in Article 14. And second, that stateless people do not enjoy any legal protection in the international sphere. Then, Your Excellencies.
That's only true if we were to hold that it is not possible in these circumstances to establish a special interest. It may well be the case that particular jurisdictions that are party to the convention may be able to show a sufficient interest in order to enforce those provisions. So it's not necessarily the case that the treaty would be left completely unenforceable.
Your Excellency, we respectfully disagree on this regard for the following reason. The obligations established under the 1961 Convention has as beneficiaries individuals, not states. In this regard, it is difficult that a state could argue that its right had been violated with a violation of the 1961 Convention. In this regard, we accept that no state possibly would be in a position to raise a claims on the notion of special affected under Article 42 of the 12 Articles on State Responsibility. However, we are also aware that in a case in which the individual is rendered without a nationality, neither any state would be in a position to exercise diplomatic protection. And that is why we claim that erga omnes partes standing is the only way in which the 1961 Convention, for its core obligation, can be enforceable before this court.
Agent, are you assuming in your argument that there is an imperative legal regime applicable to nationality and the right to hold the nationality and not to be deprived of it?
I'm sorry, Madam President, could you please rephrase that question?
It is the question of the right to have a nationality.
Of course, Madam President, we submit that there is a customary right to a nationality, which includes the prohibition of the private individuals of their nationality, which is reflected in several treaties, such as the European Convention on Nationality, the American Convention of Human Rights, and also in other instruments, such as the Universal Declaration of Human Rights. It is the applicant's submission that this right is fundamental for the basic rights of the human person, and as it was recognized by this court in the Barcelona Traction decision of 1970, with these characteristics, its rules must also be considered erga omnes. For all these reasons, Your Excellencies, we submit that the applicant has a standing to bring the matter of the Storm 40 before this court. So, unless Your Excellencies have any further questions regarding the first submission, I will move into the second submission concerning Remisia's violations of international law. This submission is divided in two parts. First, the respondent has violated the 1961 Convention on Statelessness, and second, has violated the customary prohibition of arbitrary deprivation of nationality. Regarding the first part, Your Excellencies, Article 8.1 of the 1961 Convention establishes the general rule in international law, according to which a state may not deprive an individual of his nationality if such a deprivation would render him stateless. If I may lead you to paragraph 34 of the compromise, you will see that after the protest conducted in Remisia, 40 students were deprived of their remission and sole nationality. This was a clear violation of Article 8 of the treaty.
But Article 8 has the possibility of derogations. I mean, 8.1 posits that you shall not act so as to revoke nationality if it leaves the subject stateless, but the other provisions recognize that you can in certain circumstances.
That's correct, Your Excellency, and it is true that Article 8.3 allows for certain exceptions to the general prohibition of Article 8.1, and it is also true that pursuant to paragraph 62 of the compromise, the respondent has made a declaration invoking that article. However, we submit that the respondent's declaration amounts to an impermissible reservation, and this is because of the following reasons. Article 8.3 establishes a very narrow set of circumstances in which this right can be retained. Declarations made under this article, which exceeds these very specific grounds, must be considered impermissible reservations, because by restricting the core obligation of the treaty in a non-permitted manner, These are contrary to the object and purpose of the Convention.
I don't understand that because Article 8.3 contemplates a specific right to make a declaration to retain pre-existing legislation. And that's what the respondent purported to do. So on the face of it, I don't see that it is a reservation. And in fact, the provision on reservations applies to a different set of articles. What I think the respondent has done is to stipulate in accordance with the terms of Article 8.3. Shouldn't that be how we see it?
Not necessarily, Your Excellency. I can see your concern in this regard. However, it is true that Article 8.3 refers to a declaration, but that declaration is conditioned to the accomplishment of the requirements which are established under Article 8.3. That is, that the previous domestic legislation to which the declaration refers must refer to conducts which are seriously prejudicial to the vital interests of the state.
And that's the question, isn't it?
Of course, Your Excellency, and we submit that neither the disrespect to the Crown Act nor its application to the Stern 40 refers to conducts that could amount to the required threshold to deprive individuals of their nationality.
How do you see the vital interests that the respondents were asserting?
I'm sorry, Your Excellency.
How do you see the vital interests that they are asserting, that the respondents are asserting? How do you characterize the vital interests?
Your Excellency, we submit that this court should analyze compliance with Article 8.3 based on an objective analysis. The respondent may try to argue that this is a self-judging provision in the sense that it is only up to the respondent to determine which are its vital interests. However, this court has been very clear about the notion of self-judging. In Djibouti versus France, it accepted the self-judging provisions of the convention involving those proceedings, but only because the treaty itself expressly delegated into the state the determination of which were its vital interests, with the wording which the state considers. In other situations in which this language was not employed, such as in Nicaragua, in all platforms, and in Gap-Chicobo and Aguimaros, the court rejected the existence of self-judging provisions and determined that it was for this court to analyze what those mean. Regarding the Article 8.3 and the vital interest requirement, this has been established as an extremely high threshold to deprive individuals of their nationality. According to the respondent itself, in page 11 of its written submissions, it requires the individual to have threatened the foundations and organization of the state. State practice, subsequent to the entry into force of this treaty, has almost exclusively recognized and applied this provision for conducts of terrorism and espionage. What is clear, Your Excellencies, is that conducts which are consistent with the right to freedom of expression can never be considered seriously prejudicial in order to justify the deprivation of nationality. This is the position adopted by the expert meeting interpreting the 1961 Convention, by the Human Rights Council, and by the United Nations High Commissioner for Refugees.
How would you define the limits for margin of appreciation of a state when it comes to the threat to the state? So where you would stop according to the international law provisions?
Your Excellency, we must analyze that threshold in the context of the 1961 Convention. And if we take a look at state practice, we will see that it is completely unprecedented that a state considers that individuals, and if I may lead you to paragraph 33, you will see which were the conducts for which they were persecuted, but were peaceful demonstrating, chanting slogans, and carrying signs, consider these conducts to be seriously prejudicial in the sense of justifying deprivation of nationality.
But the 40 people who were arrested were effectively preventing the Queen from entering her residence.
Not necessarily, Your Excellency. In the compromise, there is nothing to suggest that the Queen tried to enter into the palace, and we don't know whether the Stern 40 would move if that was the case. What we know is that the Stern 40 simply made a human chain at the entrance of the residence of the Queen, which had no material effects in Remisha, which affected in no manner the security of the Queen. And of course, that was not seriously prejudicial to the vital interest.
Do you accept that if the protesters were attacking the institution of the monarchy in this context, where the monarchy had a very, very long history, do you accept that in the particular context of this case, that could constitute a vital interest?
No, Your Excellency. And this is because of the following reasons. These provisions are also intrinsically related with the right to freedom of expression under Article 19 of International Covenant on Civil and Political Rights. Interpreting this provision, the Human Rights Committee, as the chief interpreting body of the Covenant, has recognized that penalties can never be imposed in cases in which certain forms of expression could be considered insulting or defaming to the head of a state or monarchs. This has been established in General Comment number 34 and in Bodrosic versus Serbia.
Yes, by those those comments and the jurisprudence of the committee and other bodies have come later, after the adoption of the convention and the entry into force of the convention. How can you, to some extent, rely on those documents or expressions of opinions in order to interpret the convention?
Thank you for your question, Madam President. It is the applicant's submission that not only in these documents this court should rely to understand what is the current context of what are the vital interests of the state, but also in state practice. And in this regard, we have, for example, the Kingdom of Bahrain. The Kingdom of Bahrain tried or deprived certain human rights activists for their nationality in circumstances very similar to these ones. And this was completely rejected by the international community as a whole. We have the rejection both by the Human Rights Council and also by the former UN High Commissioner for Refugees, Michelle Bachelet. And this is for the simple reason that accepting that in these cases deprivation of nationality is lawful not only would undermine the prohibition of rendering people stateless, useless, but also would simply mean that in these countries there is no freedom of expression but only for those who support the government in power. For all these reasons, we respectfully request this court to adjudge and declare that first, the applicant has a standing to bring the matter of the Student 40 before this court, and second, that the respondent has violated international law and rendering them stateless. Unless Your Excellencies have any further questions concerning the two first submissions for the applicant, I will leave the floor to my co-agent. Thank you.
Please proceed.
Thank you.
Thank you.
Madam President. Madam President, Your Excellencies, may it please the court. My name is Trinidad Gómez Barbela, and it is an honor to appear before the International Court of Justice, pleading on behalf of the applicant, the Republic of Antrano. Over the course of the next 21 minutes, I will be assisting the court with the applicant's last two submissions. Antrano's third submission is that it did not violate international law when it refused to provide remissia, consular access to Ms. Shaw during her time as a prisoner in Antrano. Antrano's fourth submission is that remissia violated international law when it refused Antrano national Dr. Tulum Alex entry to remissia as required by Security Council Resolution 99997. Your Excellencies, applicant respectfully asks this court not to lose track on what this case is really about. This is a state asking this court to part from the well-established rule in international law governing nationality. Your Excellencies, turning...
Is it not within the exclusive domain of a state to regulate matters concerning citizenship?
Indeed, Your Excellency, it is, and this was stated also by the respondent in page 25 of its written submissions. Your Excellencies, applicant agrees that state's exercise of domestic jurisdiction in nationality matters exists. However, Your Excellencies, in nationality decrees issued in Tunis and Morocco and in Nottebon, tribunals have considered that there are limits in international law for nationality to have an international effect.
But the facts of Nottebon's case were quite extreme. I mean, the facts of Nottebon's case, he secured citizenship in Guatemala within a period of 2 weeks, after which he went back to resume his activities in Guatemala. I think he acquired citizenship in Liechtenstein within 2 weeks and then went back to Guatemala. And the facts were quite extreme in Nottebon's case. And in those circumstances, what the court was saying was that when you're confronted with a situation of dual citizenship, then you have to look for the bond of nationality. And they identified a series of factors that you look at in order to establish that the bond exists. I wonder whether that's an extreme illustration of the point, where it appears that the whole purpose for which citizenship was acquired in another state was for tactical reasons, which may be it may not stand for a broad general position in the way that you're suggesting.
Your Excellency, the applicant agrees that the facts of the Nottebohm case are different to the facts at hand. However, this does not change the fact that in Nottebohm, this court was faced to the determination of when nationality has had an international effect. That was for the purposes of diplomatic protection. This would be for the purposes of consular access. And moreover, Your Excellencies, although it is indeed true that the fact of the Nottebohm case were different from the facts at hand, it is also true that several tribunals on different occasions have applied the Nottebohm judgment and the Nottebohm doctrine in different situations and also when different facts of the case applied. For instance, this can be evidenced in the 1992 advisory opinion on the Constitution of Costa Rica by the Inter-American Court on Human Rights. Also, Your Excellencies, by the European Court on Human Rights in the case Belliudi v. France. And finally, by the African Court on Human Rights in the cases of Benesis v. Tanzania. Your Excellencies, these are cases from 1992, 2015, and 2019. Therefore, Your Excellencies, it is applicant's submission that Nottebohm doctrine is alive in international law, and therefore it governs the rule of recognition of nationality in the international plane. Now,
Agent, yes, is this court bound by the case law that comes up from other tribunals, regional tribunals, human rights tribunals? What is the value that you grant to those, accord to those decisions?
Madam President, the court is not bound neither by its own decisions nor by the decisions of other courts. However, in accordance with Article 38(1)(d) of this court statute, judicial decisions are a subsidiary means of determination of rules in international law that can be very well applied to this situation in which the applicant acknowledges that, as stated by the respondent in page 25 of its written submissions, the Vienna Convention on Consular Relations does not explicitly regulate the context of a dual national, and therefore, Your Excellency, in this situation of uncertainty, in order to determine which are the rules that would govern nationality, we can use these judgments in order to regard the interpretation of nationality in the international plane, Madam President. Now, Your Excellencies, this court has identified several factors that make up for the genuine link requirement, amongst which are the habitual residence, establishment, interest, family ties, activities, and intentions for the near future. The International Law Commission further added the visits to the other state in cases of non-residence. And Your Excellencies, in this case, the lack of a genuine link between Ms. Shaw and Remisia is clear. If I may lead Your Excellencies to paragraph 16 and 19 of the compromise, it is undisputed that when Ms. Shaw acquired her Remisian citizenship in June 1st, 2016, she had been residing in Italy since 2012. According to clarification 5, it is also undisputed that Ms. Shaw never changed her residence to Remisia. And finally, Your Excellencies, Ms. Shaw never returned to Remisia again after the 2006 coronation.
Agent, could you tell us if you believe or you find any argument, a good ground to state that residence and nationality should go together?
Your Excellency, this was the very first element established by the International Law Commission and by this court in Nottebohm judgment when interpreting what nationality and what would amount to a genuine link. However, Your Excellency, applicant acknowledges that an individual could not reside in a state, and this is why the International Law Commission even provided an important element to amount to a genuine link, the visits, sorry, Madam President, you have a question?
No, it's okay.
The visits to the other case, to the other state in cases of non-residence. And Your Excellencies, if we see the facts at hand, this court should note that Ms. Shaw never returned to Remisia again after the 2006 coronation, while she had only gone twice to Remisia before in her life, which amounts to 3 times of Ms. Shaw in Remisia in her entire life, Your Excellencies.
But I wonder whether your argument suggests that these are checklists that all have to be ticked, and I'm not sure I think that's the correct way to think about it. I see these as indicia or as signposts that's suggested in the case law to guide the court in coming to an assessment whether there's a sufficient bond of nationality. And there may be a preponderance of one type of bond, and that may be sufficient. So you could have, if the person was living in one jurisdiction, for example, even if they were not in a position to make substantial economic investments, you wouldn't disagree that that's sufficient. So in this case, the preponderance of Ms. Shaw's connection with the respondent jurisdiction are the economic investments that she has made, which are quite substantial over a substantial period of time. Why isn't that sufficient? That's the first question I wanted to raise with you. But the second question I wanted to raise with you is, I wonder whether there is a difference when we think about the rights that were at stake in Notenbaum's case and the rights that are at stake here. Because in Notenbaum's case, the question was whether Liechtenstein could properly exercise diplomatic protection and its interest in diplomatic protection. And when you look at diplomatic protection, the nature of the interest is different from asserting your consular interests. And when you're looking at consular interests, it's the primary interest of the state that you're looking at. And it's possible in those circumstances to have a dual set of jurisdictions that could assert in good faith consular protection.
Your Excellencies, I will address these two questions in turn. Concerning the first question made by Judge Menon, in this case, applicant acknowledges that respondent could claim that the mining activities carried out by Lithos in Remisia could amount to a genuine link. However, Your Excellencies, the truth is that Lithos operated mines in more than a dozen states around the world. There was certainly not an exclusive or distinctive relationship between Ms. Shaw and Remisia.
But she didn't take citizenship in those dozen countries. She took citizenship in Remisia.
That is true, Your Excellency. However, even when analyzing the nationality acquired by Ms. Shaw in Remisia and analyzing these economic activities she carried out in the state, it is important to note that Ms. Saki Shaw was not the one that invested 5 million euros in Remisia. She was not the one that created 4,000 jobs to Remisia nor increased the public revenue. Your Excellencies, that was Lithos. The only thing Ms. Shaw did was the minimum requirement to obtain the Naturalization by Investment Act, which is an investment of 500,000 euros, Your Excellency.
Counsel, but Antrano in principle does not recognize any purchase nationality. So what is the importance of the concrete situation of Mrs. Shaw in this respect, if in any case for your state any purchase nationality does not matter?
Your Excellency, that is true. And it is true that Antrano has a domestic legislation since 2017 that does not recognize purchase citizenship. However, Your Excellency, the most important thing in this regard, and the claim that the applicant is bringing before this court today, is the fact that the non-recognition of Ms. Shaw's nationality raises from the concept of effective nationality. And this is the main submission brought by the applicant today, Your Excellency. And moreover,
Agent, but I would like to raise this point. Mrs. Shaw entered your country with a passport that was granted by Remisia, and the passport was stamped. So there was an administrative action that your country adopted at the moment, and what are the effects of this action in respect if you compare to the facts we're discussing now?
Madam President, the effects of this action are not the effects presented by the respondent concerning an estoppel on their declarations, on the actions by Antrano. In this regard, Your Excellencies, although Professor Crawford has suggested that although states' representatives may create estoppel through their declarations and admissions, the acts of administration of a routine character may not have this effect. In this sense, Madam President, immigration checkpoint officials do not analyze on what grounds passports are granted to citizens, but instead limit their job to verify if the documents are authentic. Moreover, Your Excellency, one of the elements of estoppel considered by this court in the Nicaragua judgment is for the individual to have legitimate expectations for in this case, the recognition of citizenship. And in this case, it is impossible for Ms. Shaw to have legitimate expectations Since every entrant and port of entry informed travelers that passports obtained through this purchased citizenship were not valid for entry. Therefore, Your Excellencies, the elements in estoppel are not done in this case, and therefore, Your Excellency, concluding this third submission by the applicant. It is applicant's submission. It did not have an obligation to recognize Ms. Shaw's remission nationality. And as a second point, Antrano is not stopped from denying recognition to Ms. Shaw. This would conclude that Antrano had no obligation to respect the Vienna Convention on Consular Relations between Remissia and Misaki Shaw. There are no further questions regarding this third submission.
No further questions.
May it please the court, I will now turn into the fourth submission made by the applicant. Your Excellencies, in this fourth submission, Antrano will demonstrate that Remissia violated international law by denying Antrano national Dr. Tulum Alex entry to Remissia, as required by Security Council Resolution 99997. Your Excellencies, if I may lead you to Annex A of the compromise, you will see that days after Remissia deprived the Stern 40 of their nationality, the Security Council unanimously adopted Resolution 99997. There were two crucial provisions in this resolution. Operative Clause 1 creates the UN inspection mission to Remissia, consisting of 8 civilian experts that would conduct an investigation through the deprivation of nationality. Operative Clause 2 calls upon Remissia to fully cooperate upon the mission. Dr. Malex was selected to lead the UN inspection mission to Remissia, and Your Excellencies, Dr. Malex was never allowed into the territory. Your Excellencies, applicant's main claim and the crux of the issue that this court has to decide today is whether Operative Clause 2 of Resolution 99997 creates a binding obligation upon Remissia. It is applicant's submission, it does. And this is because the context, subsequent practice, and intentions of the Security Council proves this provision binding.
Can a binding obligation be created under Part 6 of the Charter?
Certainly, Your Excellency. This was addressed by this court in the Namibia advisory opinion, when this court considered that the bindingness of an operative clause shall be raised out whether the operative clause was adopted under Article 25 of the United Nations Charter. Article 25 states that states shall carry and accept the decisions of the Security Council, and this court considered in the Namibia advisory opinion that this would apply to every decision of the Security Council, no matter under which chapter it was enacted. This is contrary to what the respondent brings in its written submissions in page 34, when respondent concerns that Article 6 only refers to recommendations. Your Excellencies, this is simply not what this court has sustained in the Namibia advisory opinion.
Ms. Agent, in the UN practice, fact-finding missions have been established under Article 34 and so on, but normally or usually the United Nations tries to get the authorization or the consent of the state that is going to be participating in the process of fact-finding. So how do you think about this, the possibility of getting the authorization of the respondent?
Your Excellency, it is true that the General Assembly even released a United Nations General Assembly Resolution 1659 in 1991, considering in its Article 6 that consent must be needed from states. However, Your Excellencies, articles later, in Article 20, the General Assembly stated that that state should give reasons for its decision, and in Article 21, that states should follow a policy of admitting the missions into the territory. We should also regard the practice of states when not allowing missions into the territory, such as has been the case, for instance, of Albania, Yugoslavia, and Bulgaria, when not allowing the mission created in the Greek frontier incident into their territory. This was heavily condemned by the international community, Your Excellencies. And the subsequent practice of states is very relevant, as has been considered by this court in Namibia and Kosovo advisory opinion, in order to determine the bindingness intent of the Security Council. If I may lead Your Excellencies to the subsequent practice at the moment of adopting this resolution, you will note that after Remisha did not allow Dr. Malek into the territory, the members of the Security Council and the Secretary General of the United Nations stated that this was a violation of the powers of the Security Council under Chapter 6. Moreover, Your Excellencies—
But the Security Council didn't pass a further resolution, did they?
Your Excellency, it is true. The Security Council had all its willingness to pass the further resolution in order to ask for further measures to Remisha. Unfortunately, Your Excellency, this resolution could not pass because of the veto of one permanent member. However, I see your concern in this regard, Your Excellency, but this does not change the fact that in the Kosovo advisory opinion, this court explained that we should not only regard the practice of the Security Council as a whole, but the practice of each state in the Security Council. And in this regard, Your Excellency, in the Secretary General of the United Nations took the matter in accordance with resolution of 66262 of the General Assembly. And they took the matter before the General Assembly of the veto of that permanent member. And members of the Security Council, including Antrano, of course, expressed concern over the use of veto, as can be seen in Clarification 9. Therefore, Your Excellencies, states were deeply condemning Remisha for not allowing the mission into the territory. And even more decisive is the fact that we should analyze the aim and the context in which this resolution was adopted. Reading the two provisions together, this court should note that the aim of Operative Clause 1 is to create a mission that would conduct in-person interviews through the deprivation of citizens with prisoners, Your Excellencies, that were being held in the territory of Remisha. Your Excellency—
Agent, what do you think about the question that the nationality of the head of the mission is the nationality of your own state, and it may run counter of the some elements of the declaration that was adopted by the General Assembly in order to have a general framework, legal framework for fact-finding missions? The question of impartiality.
Your Excellency, Madam President, sorry. It is true that the head of the mission was Dr. Malek and was an Antrano national. However, there are two answers. First, Your Excellency, that Dr. Malek was a world-renowned expert in matters related to statelessness. And second, Your Excellency, this court stated in the application for review of judgment number 158 of its judgment in 1973, this court stated that in the exercise of the powers, in that case of the General Assembly, when creating subsidiary organs, this court, Your Excellency, cannot intervene in the decisions in order for the General Assembly in that case to effectively exercise its functions. And this is why applicant's submission is that this was a decision of the Security Council that should be respected by Antrano, by Remisha, and also by this court, Madam President. Your Excellencies, Remisha violated Resolution 99997, which was binding, and this would conclude Remisha's submission. May it please the court.
Yes. Thank you. I thank the applicant. And now I call upon the respondent to take the floor.
Madam President, Your Excellencies, good afternoon, and may it please this honorable court. I am Ignacio Villarreal, and together with my co-agent, Ms. Chinzen Viernes, and her off-counsel, Ms. Pauline De Leon, we respectfully enter appearance before this honorable court on behalf of the Kingdom of Remisha, the respondents in this case. For 22 minutes, I will be discussing the first and second submissions, namely that first, Antrano lacks standing to bring forward a dispute regarding the deprivation of nationality, and second, that Remisha complied with international law when you deprived the Sterin 40 of the Remishan citizenship. For 21 minutes, my co-agent will be discussing the third and fourth submissions regarding Ms. Saki Shaw and UNSC Resolution 99997. We would like to reserve 2 minutes for Sir Rebuttal. If it pleases Your Excellencies, I'll be proceeding with my submissions.
Proceed.
Thank you, Your Excellencies, and may it please this honorable court. Your Excellencies, the monarchy of Remisha is embedded in its social, political, and even spiritual order. While we do recognize our obligations under the Convention on the Reduction of Statelessness, this very convention continues to allow Remisha
to protect its vital interests. In support of our first submission, Your Excellencies, we note that the applicant lacks standing to bring forward a claim regarding the deprivation of nationality. To this point, the applicant makes two arguments. First, that the obligations under the Convention are erga omnes partes, and second, that they are erga omnes. I shall deal with each argument in turn, Your Excellencies. First, on the claim that they are erga omnes partes obligations. We would note that the standard required by this court for an obligation to be erga omnes partes is that the particular convention forwards a common interest among all state parties.
A collective interest.
Common or collective interest,
Yes.
Your
What is the
Excellency.
rationale behind that? What do you think is the rationale? Why is it that that's a requirement?
It's because, Your Excellencies, if an interest is common, then any violation of the treaty would have a legal interest or will give a legal interest to all other states since it'd all be affected by any particular violation. And this is precisely, Your Excellencies, why the Convention on the Reduction of Statelessness is different from the conventions on torture and genocide, where this court has found them to contain erga omnes partes obligations.
How is that so?
Your Excellencies, in the conventions against torture and genocide, the court found that state parties, in light of their shared values, had a common interest in the fulfillment of the obligations. Because, Your Excellencies, it is clear in the conventions that there is a clear humanitarian, moral, or civilizing purpose to the convention.
But you can have different types of collective interest. There may be humanitarian interests in the case of those conventions. There may also be very practical and pragmatic concerns that are shared by all nations. Because if you expel your citizens and leave them stateless, where are they going to go? They have to go somewhere, and they have to go to other countries, and it becomes somebody else's problem. And it's to prevent that, surely, that you have a convention against statelessness, to prevent that sort of situation as much as you possibly can.
Your Excellencies, we do recognize that there can be a collective interest even if states are self-interested. But in the context of statelessness, it is not a collective interest, because a state would only be interested in another state's deprivation of nationality if the stateless person has to interact with their own state.
Agent, yes, may I ask you the following? The convention is not about the conditions to deprive a certain person of his or her nationality. The convention is about the reduction of statelessness. So the object and purpose of the convention should be challenged by the deprivation of the nationality in any given case. What do you think about my assertion?
Your Excellencies, we do recognize that the object and purpose of the convention is the reduction of statelessness. What we dispute with the applicant, however, Your Excellencies, is that the rationale for why states care about the reduction for statelessness is not the protection of a shared humanitarian or moral value or some collective interest, but states were rather more self-interested with respect to individual cases of statelessness. And thus, it's not a common interest, Your Excellencies. The only time a state would be interested in an individual deprivation of nationality or a case of statelessness is if that state is particularly affected by the breach. For example, Your Excellencies, if a state would deprive its citizens of their own nationality and these stateless individuals move to another state, then that state could be specially interested and therefore bring forward a claim. But in this case, Your Excellencies, what we are disputing is that not in every single case of statelessness, all state parties to the convention would have a legal interest. In the same way, Your Excellencies, that the conventions against genocide and torture have shown to have a legal interest because states want to protect their common values.
But, Agent, the concern of the applicant in the present case is not the statelessness as such, but more the arbitrary deprivation of citizenship that led to statelessness. So how you can comment on this?
Your Excellencies, this leads to the second part of the test in the determination of an erga omnes partes obligation. We submit that the particular obligations cited by the applicant, which are Article 8 and 9, are not actually integral to the object and purpose of the Convention on the Reduction of Statelessness. We would note, Your Excellencies, that preliminarily, the fact that the obligation, such as Article 8, allows for multiple exceptions suggests that states themselves, when entering into the Convention on the Reduction of Statelessness, did not consider the particular obligation to be such importance with respect to the object and purpose.
I'm not sure I agree with that. I mean, Article 9 has no derogations at all. And Article 8 does not have multiple derogations, but it contemplates acts of disloyalty to the state and conduct in a manner seriously prejudicial to the vital interests of the state. And as your colleague on the other side of the bar table proposed to us, it's clearly recognized to set a very high threshold.
Your Excellencies, we'd have to respectfully disagree. We note, Your Excellencies, that Article 9 cannot be read in isolation, and that Article 9 must be read in conjunction with Article 8. This is because, Your Excellencies, Article 8 is the special rule, while Article 9 is a general rule. We note that Article 9 generally prohibits deprivations of nationality, and Article 8 applies when this specific deprivation renders an individual stateless. And pursuant to the principle applied by this court in the nuclear weapons case, where you apply the lex specialis rule, we submit that Article 8 must be read as an exception to Article 9. So while we do recognize that the text of the convention does not expressly provide for exceptions even in Article 9, the exceptions under Article 8 must also apply. If not, Your Excellencies, then there'd be no situation where the exceptions under Article 8 can be invoked, as the rule in Article 9 would always apply, prohibiting the deprivation of nationality.
But Article 9 is itself limited. It says a contracting state may not deprive a person or group of persons of their nationality on 4 specific grounds: racial, ethnic, religious, or political grounds. So it's a very specific provision. It identifies the grounds in which you can't derogate.
Your Excellencies, to clarify our point here, we are making the claim that in the relevant ground here, the political grounds, that in the context of political grounds, disloyalty or actions inconsistent with their duty of loyalty to the state, which is a permissible exception under Article 8, paragraph 3, cannot be considered included under Article 9, Your Excellencies, and would be an exception to Article 9. Thus, in both the obligations cited by the applicant, it must be read that the states allowed for permissible exceptions for when a state can deprive nationality, suggesting that the particular obligations are not so integral to the object and purpose of the convention, which would require it to be erga omnes partes, Your Excellencies. With respect then to the second point of the applicant, that the obligations are erga omnes, we submit that this court in its Barcelona traction decision was very clear that there are only 2 sources of an erga omnes obligation. The first, Your Excellencies, is an obligation that stems from the general body of general international law or customary international law, Your Excellencies. And the second is from treaties of a universal or quasi-universal character. We submit that the obligations under the Convention on the Reduction of Statelessness have not met either of these requirements. The applicant claims that the right to nationality is a customary international law rule, but their main evidence for state practice is only certain bodies or regional instruments that enshrine the right to nationality, such as the American Charter for Human Rights and the European Convention on Nationality. This does not represent a widespread practice that is practiced in other regions of the world. In fact, Your Excellencies, we would note that the ICCPR does not even enshrine the right to nationality in general and limits the right to nationality only for children, Your Excellencies.
Are you saying that there is no basic right to nationality, or that there is no non-derogable basic right to nationality? What exactly is your position?
Your Excellencies, we submit that there is no basic right to a nationality, as this is governed and the practice of this is different in different regions around the world. And thus, Your Excellencies, we submit that the state practice requirement for this applicant to establish custom is not met. But even assuming, Your Excellencies, that these treaties cited by the applicant represent state practice, it is not clear, Your Excellencies, if the treaties entered into or cited by the applicant reflect an opinio juris, or a belief that there was a legal obligation for states to enter into these particular conventions as a result of their obligations under international law.
But what about the declarations within the convention and in the 1954 resolution that led to the convention, which all spoke about the importance of working to eliminate, and if not at least to reduce statelessness?
With respect to the specific convention, Your Excellencies, we would note that even to this date, only 80 parties are state parties to the convention, which is not even a majority of states in the United Nations, Your Excellencies, suggesting that there is no sufficient widespread or representative practice with respect to the particular obligations under the convention, which deals with also, Your Excellencies, the second point, that they cannot base the erga omnes nature of these obligations on the fact that the particular treaty is universal or quasi-universal in character. Given just simply, Your Excellencies, it has not reached that widespread level of acceptance. Thus,
Agent, but here the applicant is not affirming that it is a universal convention. It is a convention that is applicable between the applicant and the respondent. So it is interpretation within the convention and within that context that is important to assess whether there is or there is none that kind of erga omnes obligation.
Your Excellencies, we do
What do you
recognize
think about this?
I recognize the concern, Your Excellencies. To clarify our point here, we first dispute the existence of an erga omnes partes obligation. So we do recognize that both the applicant and the respondent are bound by the Convention on the Reduction of Statelessness, and we submit that the applicant does not have standing with respect to that particular ground because the obligations do not create or protect a particular common interest. My discussion with respect to the universal acceptance of this convention is to respond to the applicant's second claim that the obligations are erga omnes, or owed to the international community as a whole. But even if this court is not persuaded, Your Excellencies, that the applicant does not have standing, we submit that on the merits, Remisha still complied with their obligations under international law. Which leads me, Your Excellencies, to our second submission. To this point, Your Excellencies, the applicant makes two arguments. First, they cite Article 8 of the CRS, and second, they cite Article 9. Again, I will respond in these arguments in turn, Your Excellencies. First, with Article 8. We would note that the applicant first claims that Remisha made their impermissible reservation. We submit that this is incorrect, as the declaration made by Remisha in paragraph 62 is not a reservation, but rather it is a unilateral statement that avails of an option in a treaty, which has been clarified by the International Law Commission in their Guide to the Practice of Reservations of Treaties in Guideline 1.5.3, as separate and distinct from a reservation. And thus their claims, Your Excellencies, that the reservation is impermissible just do not hold merit. But the second point of the applicant is that the particular application of the law to the Steren 40 did not rise to the level of an action being seriously prejudicial to the vital interests.
What is the vital interest at stake?
In this case, Your Excellencies, the vital interest is the protection of the reverence and respect for the monarchy of Remisha.
But the protests were really driven by their concern over cobalt mining. That's what the students were concerned about. And I think repeatedly when they made statements in the beginning, they were really just saying that we are concerned about the health of our nation. That's what the students were saying.
Your Excellency, I would like to make a distinction between the initial form of the protests, which were primarily targeted at the environmental concerns and the mining operations, to the particular protests conducted by the Steren 40, which have crossed the line from an environmental protest to actions that are targeted towards the institution of the monarchy.
But is it right to look at that last point without seeing it in context? I mean, when somebody raises an issue about cobalt mining, and if they're shouted down or ignored and told to be quiet, the situation degenerates.
Yes, Your Excellencies, we do recognize that context may be important. But we note, Your Excellencies, that when the actions have crossed the line with respect to the protection or the reputation of the monarchy, then the vital interests of Remisha are then entitled to protection. We would note, Your Excellencies, that we complied with this obligation on two levels. First, even if we apply the objective test cited by the applicant, the protection of the reputation of the monarchy is a vital interest. The definition of vital interest cited by the applicant in their oral submissions and written submissions includes the protection of constitutional foundations.
Does that override the interest of the people in public health and well-being?
Yes, Your Excellencies. We would note that the definition of vital interests under the UN High Commissioner's Guidelines for Statelessness number 5 recognizes the protection of constitutional foundations, internal and external security, Your Excellencies, suggesting that these are the vital interests that would be paramount in a particular case. In the context of Remisha, which is a constitutional monarchy, Your Excellencies, where respect is demanded by the Constitution, as seen in paragraph 8. And furthermore, the authority and legitimacy of the government is derived from the appointment of the monarch. It is a vital interest for Remisha to make sure that the citizens of Remisha continue to respect and revere the monarchy, as that is what creates stability within the region.
Does,
Council.
sorry, please go ahead. Please go ahead.
Please do.
Council, just I bring your attention to the general comment, Human Rights Committee General Comment number 37, concerning peaceful assemblies with a clear political message that, according to the Human Rights Committee, should enjoy a heightened level of accommodation and protection. So how does it correspond to the paramount nature of the vital interest you described?
Your Excellencies, we do recognize that the Human Rights Committee does make pronouncements that there must be high protections with respect to the rights. But the rights, even under the ICCPR, Your Excellencies, are not absolute and can be subject to specific restrictions, especially in the protection of interests of the state. In the context of Remisha, Your Excellencies, we submit that that vital interest is indeed the protection of the reverence of the monarch. But if this court is not persuaded, Your Excellencies, that on an objective level, the protection of the reputation of the monarch constitutes a vital interest, we submit, Your Excellencies, that this court, in the case of Djibouti versus France, recognized that states must be given discretion in the determination of what constitutes their interests. We do note that the applicant argues that this particular provision under Article 8 is not a self-judging provision, and therefore is not entitled to discretion. We disagree, Your Excellencies. The requirement for a provision to be self-judging, as provided for by this court in the 2023 Certain Iranian Assets case, is that the particular treaty expressly provides discretion to a state to make that determination. In this case, Your Excellencies, while the Article 8 does not say that the state must consider a vital interest, we invite this court to examine Article 8, paragraph 4, which empowers the courts or independent body of the state to make a determination prior to depriving nationality. This suggests, Your Excellencies, that the convention itself granted discretion on the part of states to make the determination of what constitutes their vital interests.
Agent, but a due process determination or a determination under a due process concept is a very important principle of current international law and the international human rights law. What do you think about the possibility of looking at, you mentioned the context and the whole procedure, where you have some persons deprived of nationality going through a procedure and then having the same response all the time, according to the due process standard?
Your Excellencies, the due process requirements under Article 8.4 of the Convention on Reduction of Statelessness merely requires that the particular deprivation is first provided by law, which is met in this case, given that the disrespect to the Crown Act expressly provides for the power of the deprivation of nationality. And second, it requires a fair hearing before an independent body or court. We would note in this case, as seen in paragraph 34 of the compromise, not only did Remisha have access to a court in the lower courts of Remisha, but their case was appealed to the Supreme Court of Remisha, where it ruled with finality with respect to the deprivation of nationality. This suggests, Your Excellencies, that throughout the process, Remisha complied with the procedural requirements under the convention.
Are you suggesting that if Remisha affords a local due process, that precludes review at the international law level? Do you go so far?
No, Your Excellencies.
Yeah.
We'd recognize...
So it's just one further requirement, right?
Yes, Your Excellencies.
Yeah.
Although we would note that in Djibouti versus France, the standard of review applied by the court when the particular clause is self-judging was to allow for as long as the particular obligation was complied in good faith. We would note, Your Excellencies, that since time immemorial, Remisha has been consistently insisting on the protection of the vital interests of the monarchy, given how central it is to the state of Remisha.
But you, I hesitate to think that that interest could be almost unconditional, which you seem to suggest it is.
It's not unconditional, Your Excellencies, even in the interpretation of the laws of Remisha.
So it's a question of how you define the limits to that principle.
Yes, Your Excellency. And I think the limits are defined by the DCA itself, as seen in paragraph 7. It is not sufficient for a particular actor's speech to threaten, insult, or defame the monarch. At most, Your Excellencies, under the Disrespect to the Crown Act, it will merit a penalty of imprisonment. The line that is being drawn by Remisha is when a particular action constitutes a form of disloyalty against the state of Remisha. And that's the only time, Your Excellencies, that nationality can be deprived. We would note that there are thousands of protesters with respect to the environment, but Remisha only deprived the nationality of the Sterren 40 because their action of conducting a human chain along the Sterren Palace clearly showed contempt not just to the policies of the Remisian government, but directly targeted to the institution of monarchy as a whole.
But do you believe that the legitimate interest you protect, the vital interest, could not be achieved with less severe measures than deprivation of citizenship?
Your Excellencies, I've noted that my time has elapsed. May I just ask for a brief extension to answer the question?
Please conclude your statement.
Thank you, Your Excellencies. Your Excellencies, we would note that given that the Sterren 40 have shown to be disloyal to the state of Remisha, the only penalty that can be imposed to an individual who refuses to reciprocate with their duty of loyalty but continues to benefit from citizenship is for a state to preclude them of that citizenship, Your Excellencies. And therefore, there's no less intrusive means for us to apply. Your Excellencies, should there be no further need of my assistance?
Thank you.
I thank this court for its time and indulgence, and may it please this honorable court.
Thank you. Co-agent, please. Take the floor.
Madam President, Your Excellencies, good afternoon. My name is Chinzen Tanyada Viernes, second agent of the Kingdom of Remisha, the respondent of this case. For the next 21 minutes, I will be discussing our third submission, that Antrano violated international law when it refused to allow Remisian consular representatives to have access to Ms. Saki Shaw while she was held prisoner in Antrano. In our fourth submission, that Remisha did not violate international law when it denied entry to Dr. Malik's. With this court's permission, I would like to proceed with our submissions. Thank you, Your Excellencies, and may it please this honorable court. Beginning then with our third submission, Your Excellencies, it is ironic that the applicant claims to champion the protection of individuals from statelessness, while simultaneously denying the recognition of a nationality, thereby thwarting the very enjoyment of rights it allegedly seeks to protect.
No, they're protecting statelessness. They're not. I don't necessarily see those as inconsistent.
We understand this view, Your Excellencies. However, Your Excellencies, stateless individuals are also deprived of the right to being granted consular protection by their state of nationality. While we do not submit that Ms. Saki Shaw in this situation was rendered stateless, we do still submit that she was still deprived of her access to consular protection by Antrano not recognizing her Remisian nationality. Now, Your Excellencies, the applicant argues that the Kingdom of Remisha is not entitled to the rights of a sending state under Article 36, as Ms. Saki Shaw's Remisian nationality is not entitled to recognition. The applicant cites subsidiary means for determining that there is an alleged customary rule requiring a genuine link in conferring nationality. However, Your Excellencies, we would like to note that the applicant has failed to discharge its burden of proving both state practice and opinio juris in establishing the customary character of this rule pursuant to paragraph 77 of the North Sea Continental Shelf cases. On the requirement of state practice, Your Excellencies, we note that states are not in the practice of providing a uniform standard in conferring nationality. We have countries which do provide or confer nationality on the basis of birthplace, of marriage, of investment. We also have countries which confer nationality on the basis of athleticism, for example, in order to allow certain individuals to play in the national team of their country, they do confer nationality.
As I understand the applicant's case, they don't contest the fact that your government has the right to confer nationality. What they do contest is the question of whether they are obliged to accord recognition as a matter of international law. And their contention is that they're not obliged in certain circumstances. And one of those circumstances, for instance, is in the context where a given subject holds dual nationality and there are assertions of consular rights by more than one jurisdiction. They say that they're entitled to not recognize the secondary state in certain circumstances. And this is such a case.
We understand this, Your Excellencies. However, we first note that the applicant accepts in its written and oral pleadings, Your Excellencies, as pursuant to this court's opinion in the nationality decrees, that when nationality is conferred consistently with international law, then it must be recognized for all intents and purposes. Now, the applicant thereafter argues that a citizenship granted through investment is inconsistent with the customary rule requiring a genuine link, and that is precisely what we are disputing in this situation. We note that on the requirement of opinio juris, Your Excellencies, we also note that the applicant has failed to discharge its burden of proving that for states who do require, for example, a minimum period of residence or the presence of familial ties, that such countries do so from a sense of legal obligation. On the contrary, states have always recognized nationality conferred by way of investment as in fact similar to the Kingdom of Remisha. States have granted nationality on the basis of investment, and it is still within the exclusive competence and sovereign right for every state to determine who its nationals are and how it is conferred. Now, Your Excellencies, we do understand that the applicant also argues in the alternative that in a situation where there is a dual national invoking the rights under Article 36, only the predominant and effective state of nationality is allowed to exercise, and it cites this court's ruling in the Not-Bomb decision. However, Your Excellencies, we would humbly submit that the Not-Bomb ruling does not apply in this case for three reasons.
Co-agent, do you find any provision in the Vienna Convention on Consular Relations regarding this subject that could guide your argument or to understand better your argument?
Indeed, Your Excellencies. Preliminarily, Your Excellencies, we do recognize that Article 36 does not provide for explicit rules governing dual nationals. However, we can glean from the text, in light of its object and purpose, that it never intended to exclude any sending state. In fact, Your Excellencies, under Article 72 of the VCCR, it provides that the receiving states shall not discriminate as between any states. In this case, Your Excellencies, the applicant discriminates the Kingdom of Remisha by way of how it chooses to confer nationality. Your Excellencies, on the note of the applicant's argument citing Not-Bomb, we submit that first, the Not-Bomb ruling does not apply, as the Not-Bomb decision involved the case of diplomatic protection and not consular protection. We humbly submit that there is an important distinction between the two. On the first hand, Your Excellencies, diplomatic protection involves the espousal of a state of a claim of one of its nationals. Its very objective is to remedy a wrong that has already happened. In consular protection, Your Excellencies, as clarified by the International Law Commission, the very object of consular protection is the prevention of a wrong. And the prevention of a wrong, Your Excellencies, entails that we act in an appropriate and timely fashion in order to provide adequate protection for the individual who is put in a very vulnerable situation of being held prisoner in a foreign land. Which is precisely why, Your Excellencies, in this case, Ms. Saki Shaw made immediate and numerous requests to have access to remission consular representatives. recognizing.
I wonder whether that cuts against you, because I understand your point about the distinction between diplomatic protection and consular protection, but I wonder whether in a situation where it is the case that one of the requesting parties is actually seeking the extradition of the subject, if the real object of consular protection is the prevention of a wrong, isn't it intuitively the case that you should have prioritized the state, the request of the state that was seeking to protect the subject?
We would humbly disagree, Your Excellencies, and we submit, Your Excellencies, that this interpretation would disregard the will of the individual, which is given utmost importance by not only the text of Article 36, but also the pronouncements of this court and other international tribunals.
So you suggest that the consulate protection includes a right of individual to choose in case of dual nationality. This is your submission, if I
Absolutely,
understand
Your
correctly.
Excellencies. Indeed, Your Excellencies, and this has been supported by this court in paragraph 89 of the Legrand decision, therefore clarifying that Article 36 not only grants rights to the sending state, but also to the individual involved. And this is seen in the very text of Article 36. First, Your Excellencies, in Article 36, paragraph 1c, where the individual may choose to oppose action from a consular or a sending state, Your Excellencies, and furthermore in Article 36, paragraph 1b, where the exercise of consular notification is contingent only upon the individual's will. And this was supported by the Inter-American Court of Human Rights in its advisory opinion on Article 36 of the VCCR, providing once more that the exercise of consular functions is contingent only upon the individual's will. In this case, Your Excellencies, when Antrano refused and disregarded the immediate and numerous requests of Ms. Saki Shaw to have access to consular protection from the Kingdom of Remisha, Antrano clearly violated Article 36 of the Vienna Convention on Consular Relations. Moving then to our fourth and final submission, Your Excellencies, the applicant argues that the Kingdom of Remisha violated Article 25 of the UN Charter. Now, Your Excellencies, we do recognize that Article 25 provides that member states are to accept and to carry out the decisions of the UN Security Council. And in determining whether the UN Security Council is acting under its powers under Article 25 through a resolution, this court, in its Namibia advisory opinion, looked into three factors. First, the provisions of the UN Charter invoked and the prior discussions leading to it. Second, the language of the assailed resolution itself. And third, in general, all circumstances which might help this court in its determination. We discussed these factors in turn, Your Excellencies, and we submit that the UN Security Council did not intend to impose legal obligations on Remisha. First, Your Excellencies, on the provisions of the UN Charter invoked, we note that as seen in Annex A of the Compromise, the UN Security Council did not invoke Article 25 of the UN Charter, and this is contrary to the practice of UN Security Council. For example, in the Namibia advisory opinion, when the assailed resolution therein was held to be binding because the UN Security Council expressly invoked Article 25 of the UN Charter. Such invocation is absent in this case. Furthermore, Your Excellencies, we draw your attention.
Agent, is it necessary to have an express reference to Article 25 in order to have a mandatory resolution or to have an obligation to cooperate with the UN system? What's your view about that? Because Article 25 is not embedded in one specific, either Chapter 6 or 7 of the UN Charter.
Indeed, Your Excellencies, while we do recognize that resolutions under Chapter 6 may be binding, the court was very clear in its Namibia advisory opinion that to determine whether that resolution under Chapter 6 must be given binding effect, we not only look at the invocation of a UN Charter provision, but also the language of the resolution. We recognize, Your Excellencies, that the lack of invocation of Article 25 does not automatically determine that the resolution is non-binding. However, in this case, Your Excellencies, even the language itself of the resolution would suggest that the UNSC did not intend to impose legal obligations. We note, Your Excellencies, that the UNSC...
I don't understand this point, because the Security Council established the mission and clearly contemplated that the mission would conduct in-person interviews of people within Remisia. And it seems difficult for me to square that with the proposition that the Security Council was not intending to bind Remisia.
We understand this concern, Your Excellencies, and we do not contest that the UN Security Council in this case had truly the powers to investigate any situation or any dispute which might lead to international friction. And we do submit that the UN Security Council can adopt binding resolutions under Chapter 6, or more specifically under Article 34. However, our submission today is that when the UN Security Council intends to impose legal obligations under Article 34, it would use stronger mandatory language. For example, Your Excellencies, in prior resolutions by the UN Security Council, the Security Council would use words such as demands and requires. This language would lead to no other conclusion than the fact that the Security Council wanted to impose obligations. In this case, Your Excellencies, as seen in Annex A of the compromise, it merely calls upon Remisia to cooperate with the mission. This recognizes that while the UN Security Council does have the power to investigate, it also respects the sovereign right of every state to voluntarily cooperate and still respect the sovereignty of each state, Your Excellencies.
But this isn't a question of sovereignty. I mean, this mission was predicated on the premise that there was a breach of international law insofar as the deprivation of statehood, of nationality was concerned. And that was what the Security Council was investigating, to see whether it was a threat to peace and security. And it decided to establish the mission and called upon your government to cooperate fully with the mission, including by providing access to all documentary and testimonial information. I mean, I don't know what else they need to say in order to convey the impression that they require that to be done.
We understand this concern, Your Excellencies. Allow me to provide examples of prior resolutions from the UN Security Council to assist this court. First, Your Excellencies, in paragraph 44 of the Lockerbie judgment, where the assailed resolution asked the member states to provide a full and effective response, such assailed resolution was still considered to be merely recommendatory. Second, Your Excellencies, when the UN Security Council intends to obligate the member state to provide freedom of entry and access to the mission in all relevant facilities of the host state, Your Excellencies, the UN Security Council would provide an explicit provision providing for the same, aside from seeking cooperation from the member state. That is seen in the UN Security Council Resolution 1595, adopted in 2005, where it was provided therein that the member state was to provide freedom of entry and access to all relevant facilities that would help the mission in its inquiry. In this case, Your Excellencies, such explicit provision is lacking in the assailed resolution. And
do you accept that at the end of the day, it's a matter of objective interpretation of the resolution to determine whether the Security Council did or did not intend to confer an obligation?
We understand, Your Excellencies, that when the UN Security Council adopts resolutions, most of the time its binding nature is questioned by the member states involved. Your Excellencies, if this court is not persuaded that the assailed resolution in this case did not impose any legal obligations, we submit, Your Excellencies, that it would be too premature for this court to find any violation on the part of the Kingdom of Remisia, because Dr. Malix in this case was only denied entry because of his inability to present a valid travel document in the form of a remission visa. We note that Dr. Malix was very well aware that remission laws do require for all travelers to present a remission visa before being allowed entry. In this case, Your Excellencies, Dr. Malix...
But that would have been an exercise in futility, wouldn't it? because the statement that the ambassador made to the UN essentially said the so-called UN inspection mission is unprecedented, illegal, and unwelcome in our country. I mean, he did go on to say that Dr. Malix could apply for a visa. I guess if he wanted to visit the country as a tourist, he could apply for a visa. But as far as the carrying out of the mission is concerned, it would have been an exercise in futility, wouldn't it?
We understand this concern, however, we would humbly disagree, Your Excellencies. We submit that this court cannot rule on a mere hypothetical, Your Excellencies, where Dr. Malix has not made any concrete action to comply with remission laws as found in the assailed resolution. We note, Your Excellencies, that
Co-agent, you're assuming that if Dr. Malix had complied with certain requirements, you would have admitted him to enter the country?
while we do acknowledge that the Kingdom of Remisha would not be too keen in granting that remission visa, when the question before this court is whether or not Remisha violated the UN Charter by way of not allowing Dr. Malix to enter.
So, Agent, you're arguing that the resolution to some extent was binding upon you, but the conditions for the functioning of the resolution had to be met.
Indeed, Your Excellencies, assuming without conceding that the assailed resolution did impose legal obligations, as found in the very text of the assailed resolution, the UN and its associated personnel are to obey and respect the laws of the countries in which they are operating. This is seen in paragraph 3 of Annex A of the Compromise, Your Excellencies. And in this situation, Dr. Malix was very well aware that the Kingdom of Remisha provides that every traveler should be able to present a valid remission visa. In this case, he did not take any concrete action towards that goal and towards complying with remission laws and regulations. We note that under Section 22 of the Convention on Privileges and Immunities, Dr. Malix, as a mere UN certificate holder, is not entitled to immunities and privileges from immigration rules and regulations of the countries in which they are operating or visiting. Thus, Your Excellencies, the Kingdom of Remisha was well within its right in not allowing Dr. Malix to enter in the absence of such visa. And this is merely an exercise of the Kingdom of Remisha's sovereign right to decide who are allowed to enter and to exit the territory.
Does it matter why? Does it matter why? I mean, the prayer for request from Antrano is that Remisia violated international law by denying Dr. Malix entry as required by Security Council Resolution 99997. And your position was that that resolution was illegal. Isn't that the reason why he was denied entry?
Your Excellencies, we do maintain our position that the assailed resolution essentially intervenes in matters falling within our domestic jurisdiction, as the investigation was mandated to inquire upon our citizenship policies, which remain to be our sovereign prerogative. This is supported by the nationality decrees and by Yin and Bosico versus Dominican Republic, where the International Tribunal pronounced that even when questions of Your Excellencies, yes. I know that my time has elapsed.
I would like to ask a final question on the subject. Are you arguing that this court has competence to pass a revision or to review the legality of a resolution of the Security Council?
Indeed, Your Excellencies, we do recognize that this court has the competence to make such a determination, as it did in its Namibia advisory opinion and its Lockerbie judgment, for example. Thus, Your Excellencies, we pray that this court declare that Remisha did not violate international law when it denied entry to Dr. Malix. Thank you, Your Excellencies, for your time and indulgence, and may it please this honorable court.
Thank you. Now you have the time for rebuttal. The applicant is invited to proceed with the rebuttal.
Madam President. Madam President, Your Excellencies, 3 points for rebuttals. First, concerning the first submission for the applicant. In order to demonstrate that the prohibition of rendering people stateless is enforceable, Respondent brought a hypothetical scenario before this court in which a state deprives an individual of their nationality, then expels the individual to another state, and then the receiving state can exercise diplomatic protection on its behalf. It seems that the respondent is referring to Article 8 on the draft articles on diplomatic protection that allows for this possibility. However, Your Excellencies, not only the respondent in page 1 of its written submissions submitted that this is not a rule in customary international law, but also, Your Excellencies, this rule requires the individual to be residing in the state at the moment it suffered the injury, which is clearly not the case of the 740 nor of the hypothetical scenario brought by the respondent. Consequently, Your Excellencies, the respondent's submission in this first submission simply has the effect of rendering Article 8 of the Convention on the Reduction of Statelessness unenforceable, and this, Your Excellencies, was deeply condemned by this court in the Belgium v. Senegal case, paragraph 69, and the Gambia and Myanmar case, paragraph 108. Concerning the fourth submission made by the applicant, Your Excellencies, in this fourth submission, respondent submitted this court that the language calls upon does not create a binding obligation. However, Your Excellencies, respondent is failing to acknowledge that this court has already relied on operative clauses started with the term calls upon to be binding. This was the case, Your Excellencies, of Operative Clause 5 of Resolution 276 in the Namibia Advisory Opinion and Operative Clause 3 of Resolution 446 in the World Advisory Opinion. Your Excellencies, the respondent will say to this court that Operative Clause 5 was binding only because it made reference to, in its preamble, to Article 25. However, Your Excellencies, the fact that an operative clause started with the term calls upon was considered binding at least shows to this court that this does not preclude the bindingness of the operative clause, and that therefore, considering the context of the resolution, this resolution must be binding. Consequently, Your Excellencies, the international community, alongside with Antrano, members to the 1961 Convention, and the Security Council, have put all their efforts for the reduction of statelessness. Yet, the UN inspection mission to Remisia was found with closed doors in the territory of Remisia. And sadly, Your Excellencies, in this case, it takes two to tango. This would conclude applicant submission. May it please the court.
Thank you. Now we call upon the respondent just to, with the rebuttal, to continue with the rebuttal. Please, sir.
Your Excellencies, 3 points of rebuttal. First, on their claim that we base the lack of an erga omnes partes obligation on the fact that other states can exercise diplomatic protection. This is a clear misrepresentation of our case. We never said, Your Excellencies, that other states can exercise diplomatic protection over the Stern 40. The main contention of the respondent is that even assuming, Your Excellencies, no state can bring a claim, that's not sufficient to grant standing before this court. That's the same argument recognized by this court in the Southwest Africa cases, where Ethiopia and Liberia made the claim that no state can bring forward the claims regarding the protection of the Southwest Africa mandate. And yet, despite that, Your Excellencies, the court found that the Ethiopia and Liberia did not have standing. With respect to their second argument,
Yes, agent, but I would like to remind you that that decision was highly divided and adopted under very specific conditions.
Your Excellencies, even disregarding that particular pronouncement, we note that the appropriate remedy under the Convention is Article 11, which grants claims to the UN High Commissioner for Refugees, and not necessarily this court, Your Excellencies, with respect to the disputes of state parties. With respect to the third point of rebuttal, Your Excellencies, we note that while previously this court has found some resolutions which incidentally use the word calls upon to be binding, that was not the rationale of this court in the Namibia advisory opinion. Instead, Your Excellencies, the court based it on the invocation of Article 25 of the UN Charter. It doesn't also reflect the current state practice, such as the recent UNSC resolution, which uses the mandatory language demands and not calls upon to invoke particular obligations, for example, in the case of Gaza and the ceasefire, suggesting, Your Excellencies, that even if this is the old practice of the court, it's not new. Your Excellencies, I note my time has elapsed. Should there be no further need of my assistance, I thank this court for its time indulgence and may it please the court.
Yes, thank you very much. Deliberate, yes, but I don't know if
The Honorable Court is now adjourned. Consular and spectators will please stay in the courtroom. The judges will leave to deliberate.
Does that work? Awesome. Okay. Perfect.
Now don't move it again.
All right. I want you to trip. And perfect.
3 minutes.
Pardon?
3 minutes.
Yep.
All right. Please take about 3 minutes to stretch your legs, and then we have. Excuse me. Wow. Please take about 3 minutes to stretch your legs, and then we will have a few announcements while we wait for the judges to come back. Thank you. Wow. Clicker for Stephen.
I've gone through it with him.
What's that?
I've gone through it with him. Hopefully it works.
Perfect. Wow.
Okay.
Yeah. Right. Tonight at the gala. Sure, I have to make an announcement. In 1 minute. Done. Good? All right. Good afternoon. I'd like to once again thank both teams for a truly, and our bench, I suppose, for a truly magnificent World Championship round. Thank you. In a moment, the judges will be back with their decision. But while we wait, I'd like to thank several very, very important people. First and foremost, our student teams, their coaches, as I mentioned on the first day, the parents, boyfriends, girlfriends, significant others, spouses, mothers, fathers, pets, everyone who's given you up for the last 7 or 8 months, who has guided you, mentored you, and gotten you to this point. Give yourselves, and by proxy them, an enormous round of applause. I'd like to thank your incredible volunteer judges who have made your life very difficult, very hot, very interesting this week. You are amazing, and it has been wonderful seeing you, my judges, once again. I'd like to thank our bailiffs who kept us in order, even Chris Coyle. Kept us in order all week, kept you in order all week, and kept the show running. Thank you very much to all of our bailiffs. I'd like to thank the 2024 White and Case International Rounds core staff, our largest ever. This includes our judges coordinator, Derek Moore. Remain standing as I mention your names, and that's Derek, why you're going first. I know you need to stretch. Our incomparable bailiffs coordinator, Thais Neves. Not appearing today because she's flown home, but our judges bailiff liaison, Jenny Englander. Judges room organizer, Megan Madamo. My predecessor and all-around utility infielder did everything we needed all week, Amity Boy. First ever Jessup International Rounds Information Desk Coordinator, Dr. Bhavna Batra. Deputy first ever Jessup Information Booth Coordinator, Nuran Chowdhury. Our student directors, cum merchandise mavens, Smriti Saroja and Larissa Ribello. The newest member of our team from White and Case, another all-around utility infielder, Madeline George. It's good to have you aboard. My longtime partner in crime, one of my best friends in the world, and my best friend in the world during this week, Elizabeth Black. And Stas. And I told you at the beginning of the week that my team is better than your team. I would be remiss if I did not thank as many times as I can from the bottom of my heart the ILSA Executive Office staff, Stephanie Corzantes, Chris Bonet, and Shannon Hutchins. Let's do a couple of awards. Many of the teams that are here have earned their ticket to Washington by prevailing in national or regional rounds. These national rounds take incredible time, effort, and energy to organize and administer. And ILSA is deeply grateful to all of our 65 national, regional, and friendly administrators around the world. But each year we like to recognize one or two national administrators or regional or friendly administrators who've stood out for their ingenuity, intensity of effort, and commitment to making Jessup the very best for the students in their jurisdictions. We have therefore established the Stephen Schneebaum Award to celebrate the achievements of these administrators. So in many countries, it's not possible for teams to compete in robust national rounds. And so a few hardy souls in Europe, in Central Asia, in Latin America, among others, have established supranational friendly rounds, bringing together solo teams from multiple jurisdictions for a non-binding event to help them prepare for these White and Case international rounds. Our first Schneebaum Award this year goes to the inventor and administrator of our newest friendly rounds, Mark Ramsey of the Caribbean Friendly. Is there someone from Jamaica to accept? Would any Jamaican team like to bring this to Mark? Come. Yeah. Come on up. Our second Schneebaum Award is a bit unusual. Over the course of the Jessup year this year, we learned that our host, our sponsor, then our first, second, and third choices for National Administrator in South Africa would not participate this year. And so left without a host, an administrator, all kinds of, pretty much anything else you would need for national rounds except teams, but with 6 or more South African teams waiting for information about those national rounds, we brought in an expert. Starting in late January, and within a matter of weeks, she contacted the teams, recruited judges, and whipped everything into shape. And the South African national rounds moved online on very, very short notice, and they were a smash success. And she did all of this while meeting all of her deadlines and duties to the international rounds as a full-time employee of ILSA. That's why our second Schneebaum Award goes to our South African National Administrator, Shannon Hutchins. So as you can tell if you've been around it all this week, and I think some of you have, the Jessup Moot Court competition is driven by our volunteers. Judges, administrators, coaches, we have had an army of hundreds of people who love the Jessup here and around the world. And the Jessup loves them. Oh yes. And so, but it's a dangerous love, all-consuming. And so many years ago, ILSA established the Pamela M. Young Award to recognize exceptional volunteer service in a given year. This is my favorite award because it's the one award that is selected by the executive director in my sole discretion. Rule 1.8a. Our first recipient of this year's Pamela M. Young Award is no stranger to anyone in the room, not least of whom those of you who attended this morning's breakfast with the authors. This person was co-author of this year's compromis and also helped invent the new system of Jessup in the United States and administered one of our new mega regionals. Whether it's been for fundraising, for helping teams around the world, or for just being a sounding board for silly ideas from the executive director, she's been there with me every day for the last year. And so it gives me great pleasure to ask Dagmar Butte to please come up here and receive my gratitude. Our second recipient is no stranger to anyone in this room, not least of which those of you who attended this morning's breakfast with the authors. This person was co-author of this year's compromis and also helped invent the new system of Jessup in the United States and administered one of our new mega regionals. Whether it has been for fundraising, for helping teams around the world, or just for being a sounding board for silly ideas from the executive director, he's been there for me every day for the last year. It gives me great pleasure to ask Jeff Brooks to come up here and receive my gratitude. And now I turn the podium over for the newest in the pantheon of Jessup International Awards. And for that, I would like to ask Aditya Singh of White & Case to come up here. Aditya is a White & Case partner focused on international disputes and investigations, qualified to practice in India, New York, England, and Wales. Aditya worked in White & Case's New York and London offices before moving to Singapore. Aditya competed in the Jessup on behalf of Nalsar University in India and is judged on the national level and here at the international rounds. He's also one of the newest members of the ILSA Board of Directors and therefore my boss. So, and a stunning dresser, very smart. And it's good to have you back here at the international rounds, Aditya. Please, Aditya Singh.
Thank you, Michael. Good afternoon, ladies and gentlemen. I'd like to begin by congratulating all the competitors at the Jessup this year. Not only the top two teams who displayed incredible advocacy skills just now, but all of the teams from across the world who participated. We know how much work goes into this, and you should all be very proud of what you've achieved. This year marks the 17th year of White & Case's global partnership with the Jessup. As a global partner, we are constantly thinking of ways to celebrate and promote the competition and all that it stands for. 4 years ago, we established an annual award to honor a Jessup alumnus who has made a profound impact on the legal profession and the world. Now, Jessup alumni have gone on to have very impressive and important careers, making a difference in the world as lawyers, judges, academics, government officials, and politicians. And for this award, we look for a visionary leader with a commitment to international cooperation, the rule of law, and the legal profession. This year, I am delighted to announce that the recipient of the award is the Honorable, the Chief Justice of Singapore, Sundaresh Menon. Chief Justice Menon participated in the Jessup in 1986. He was a member of the National University of Singapore team that was the runners-up of the international rounds that year. Today, Chief Justice Menon is widely regarded as one of the world's leading jurists who has made a significant contribution to the study and practice of international law. Before his appointment as Chief Justice in 2012, Chief Justice Menon had a distinguished career in private practice and the government. While in private practice, as a senior counsel in Singapore, Chief Justice Menon was amongst the first few from Asia who rose to prominence internationally as an outstanding international disputes lawyer, blazing the trail for many who have followed. In 2010, he was appointed as the 6th Attorney General of Singapore, a post he relinquished 2 years later before his appointment as a judge of appeal and then as Chief Justice of Singapore. As a judge, not only has Chief Justice Menon authored some of the most significant judicial decisions on international law and arbitration, he has also, through his writings and many speeches, shaped the contemporary thinking around some of the most complex legal issues facing us today. His thought leadership stands out because he has consistently been unafraid to confront difficult systemic issues and offer bold solutions. There is also broad consensus that Chief Justice Menon has made unparalleled contributions towards establishing Singapore as one of the world's leading centers for international dispute resolution. He was amongst the first to identify the trend of the internationalization of litigation and then take concrete steps to harness that opportunity with the creation of the Singapore International Commercial Court, an important step towards further strengthening the international rule of law. But apart from all of these incredible achievements, Chief Justice Menon has been a valued mentor to many and an inspiration for those who want to improve the law and use it to change the world for the better. In preparing my remarks for today, I spoke to my friend and valued colleague, Preeti Bhagnani, who is a partner in the White & Case New York office. Preeti started her career some 17 years ago as a young associate working with Chief Justice Menon when he was in private practice. And she recounted to me how, apart from being a sharp and skilled advocate, someone who easily won the trust of his clients, someone who always carved time out for younger lawyers, what stood out for her as a young lawyer back in the day, and what remains with her today, is that as an advocate, Chief Justice Menon was always values-driven and intensely focused on integrity in lawyering and a commitment to promoting justice. Ladies and gentlemen, I am privileged and deeply honored to present the White & Case Distinguished Jessup Alumni Award to Chief Justice Menon, and now we're pleased to hear from His Honor himself. Thank you.
I feel nervous. Let me begin by thanking Aditya for those extraordinarily generous remarks. They really are extraordinarily generous, and I feel deeply humbled by what he said. I think I'm one of the luckiest people in the world because I've had the tremendous privilege of being able to practice law in every capacity, as a lawyer, as a government legal officer, and as a judge, and eventually as head of the judiciary of my country over the course of 38 wonderful years. And when you feel that you're living your purpose, it feels like you're being paid to have fun. And that really has been the biggest blessing of my life, and I feel extraordinarily, extraordinarily privileged to be able to say that. And to receive the benefit of the remarks that you heard from Aditya, which are just exceedingly generous, and to receive an honor from White & Case seems completely strange to me, because I never thought I was doing anything other than just living my purpose. So I want to begin by expressing my heartfelt appreciation to White & Case for conferring this honor upon me. It really is extremely generous, and whilst I accept it with a profound sense of gratitude and humility, I do want to say that it just has been so joyful to be able to discover how you can live a life of true purpose in the practice of law. It's one of those wonderful professions that gives you an opportunity to set about doing the right thing and doing good things with the amazing training that you acquire. I also want to thank the International Law Students Association for inviting me to serve on the bench at this final round of the 2024 Jessup Moot competition. And can I say one word about the ladies and the gentlemen who are before us today? Wow. I think that says it all. My goodness, if this is reflective of the quality of today's lawyers, I think the world's going to be a good place, honestly. It really was an extraordinary privilege for me to have a small part to play in this afternoon's proceedings, and I do want to say to each one of you, congratulations, amazing performance. I can also tell you that we haven't actually decided the outcome as yet. I was pulled out to come and attend to this. That's how difficult it's going to be to decide this moot. Almost exactly 38 years ago, I stood in the same position as all of you. The year was 1986, and I was on the respondent side presenting our arguments in the case concerning the art treasures. And I still recall what a thrill it was to mark the culmination of many months of preparation, going through the hectic elimination rounds of the competition, engaging with a bench that included in the finals Judge Maxwell Cohen of the International Court of Justice, and meeting wonderful friends and lawyers from all over the world who are here participating in the same competition. My team did not prevail in the final, but the most important lesson that I learned was that when you go through an experience like this, regardless of how far you go, there are no losers. Each and every person who's participated in the Jessup Moot, I think, is a winner, because they've gone through an exceptionally demanding experience, and they've come out at the other end a transformed person. The opportunity of working closely and intensely with your team, going up against top-notch competition as you hone and refine your arguments, and then the experience of going through several moots over the course of a few days before judges who really challenge you and push you is simply priceless. And I do want to say to all of you in this audience who participated over the course of the moots this past week, and especially to you in the two finalist teams, you are all winners, and I congratulate each and every one of you. You heard Aditya say that White & Case has been supporting ILSA and the Jessup competition for 17 years now. And I do want to say something about why that is such an important contribution that's being made to this very important area of law. Over the last few years, I think the Jessup competition has become ever more relevant with the rise of public international law and its extension into almost every area of law. Indeed, I would go so far as to say that international law has become a ubiquitous part of life as a lawyer, featuring not just in disputes between states, but even in the domain of private law. A central example of this is the ever-growing field of investor-state arbitration, where domestic courts often have to deal with diverse issues of public international law, including issues relating to the interpretation of treaties, state succession, and the exhaustion of local remedies. This development, I think, exemplifies a broader trend that has been called the privatization of public international law. And as a consequence, I think it's become a useful and even a necessary part of the formation for most lawyers, including even commercial practitioners. So the ability to participate in this competition and in the process to take part in what is clearly the premier moot competition in the field of international law, I think is a perfect entry into this subject. all of you now possess a grounding in the basic principles of international law. You've learned a great deal about the rigor of an advocate's work and some of the most important lessons in interacting with your colleagues on both sides of the bar table as well as with the bench. And this is all going to stand you in excellent stead for the rest of your careers in the law. My wish and my encouragement and my request to all of you is you stay the course. The practice of law is incredibly demanding, but it is also incredibly satisfying, and it will give you many, many years of purpose and happiness. Let me conclude by once again reiterating how honored and humbled I am to receive the White and Case Distinguished Jessup Alumni Award. Ultimately, I regard myself to be distinguished only in the enormous and outstanding support that I've received from my colleagues throughout my career, and in the opportunities that I've been blessed with, in particular, the privilege of pursuing the mission of advancing justice. I accept this award in the hope that it may showcase and inspire the next generation as to what may be possible in answering a calling to serve the law. Thank you so very much, and once again, to the 6 of you, all the best. Thank you.
We had no idea they were still deliberating. All right. I'd like to thank one last group, and that is the Board of Directors of the International Law Students Association. Please stand so that we can thank you for all of your hard work. And chairing that board is our founding chair, and then I think he was our 3rd chair, possibly our 6th chair, our 9th chair, and our present chair, my friend and colleague, Stephen Schneebaum.
Well, one of the problems of being the last speaker in an event like this is that the previous speakers have stolen all of my lines. But as the regulars among you know, it is the role of the ILSA board chair, while the final round judges are still deliberating, to say a few words. I was going to say, the first word that comes to mind is wow, but that would be kind of a copycat thing, so I won't do that. But I will say, I will remind you all of what we have just seen in this room. The 2 best teams in the world, out of 650 teams that competed in the Jessup this year, and they're phenomenal. They are, again, the Universidad Torcuato de Tella from Buenos Aires, representing the applicant, and the University of the Philippines, representing the respondent, Remusia. Now, to those of you in this room and those around the planet who are watching this event in live stream, and I'm told there are many who are doing so, many of you have lived with the Sterin 40 for months, and you too need to be congratulated. There are more than 5,000 people whose lives were touched by the Jessup this year, 3,000 competitors, over 1,600 judges, hundreds of coaches, and you all, we hope, learned a lot, you committed yourselves, you made new friends, you gained self-confidence in speaking and writing, often in a non-native language, and you have demonstrated once again that your generation is committed to defending and promoting the rule of international law. But while we're thanking and congratulating, there's one person who hasn't yet been thanked and congratulated who is the key to all of this. It is a special pleasure for me to say thank you on behalf of everyone connected with this competition to ILSA's stellar executive director and my good friend, Michael Pyle. Pulling together an event like this, of this magnitude, of this complexity, requires superhuman effort, patience, and a sense of humor, and we've seen all three from Michael. ILSA's staff, Stephanie Crosantes, Chris Bonet, and Shannon Hutchins, are, as Michael told you a few moments ago, terrific. Every one of them. They're excellent. And Michael was right to tell you that. But when the ship safely completes a difficult voyage, the credit goes first of all to the captain. And Michael has been an exemplary captain of this amazing vessel. Thank you, Michael, on behalf of your entire global fan club. Now, I want one more thank you, but this one is important too. I want also to thank my predecessor as chair of ILSA's board, Mark Luz. Mark oversaw the enormous and unprecedented effort to conduct the 2021 and 2022 competitions online, and he did so with perseverance, with grace, and with complete confidence that the spirit of the Jessup would come shining through. He was right, so thank you, Mark. Now, there are three more things that I need to accomplish in the remaining minutes allotted to me, in accordance with Jessup rituals, old and new. First, I'm going to take a moment to initiate a new tradition, which I hope will be maintained as an integral part of this final round gathering. This competition began, as you keep hearing, in 1960, 64 years ago. ILSA became an independent organization in 1993, more than 3 decades ago. It is inevitable that we will each year lose some members of the Jessup family who have been instrumental in making this event what it is, or who have inspired others to invest themselves in it. So I want to pay tribute to 2 men whose lives sadly ended since we last saw each other in April of 2023. Professor Vednanda was Distinguished University Professor of Law at the University of Denver, where he taught for half a century. He was also a member of ILSA's Board of Directors in its first decade. He served as author of the Compromis in 1986 and a final round judge in 1994. Ved served as president of the World Jurist Association and as honorary vice president of the American Society of International Law. He was a friend to many of us, a renowned and distinguished international law scholar and teacher, a mentor to generations of his students, but above all, a gentle and compassionate man. Vednanda will be remembered for many things, all of them demonstrating his exceptional commitment to international law and his remarkable humility and kindness. He was the author of some 24 books and hundreds of articles, and was the recipient of in 2018 of the Padma Bhushan Award, the 3rd highest decoration conferred by the Republic of India, the country of his birth. And it is fitting that his recognition was for achievements not specifically in law, but in literature and in education. He died on the first day of 2024 at the age of 89. Now, sometimes fate takes away from us not only our old friends, but our new ones. Sarkhan Hasanov, There he is. Sarkhan Harsanov was an outstanding final year student, law student, and a presidential scholar, having achieved a perfect score on the entrance examinations at Ada University in Baku, Azerbaijan. He was tragically killed in a fire at his home in January. Sarkhan was described by his law school dean as, quote, a young man of high culture and a brilliant lawyer of the future. He was awarded the Erasmus Scholarship to spend a semester at the law faculty of Lille Catholic University in France, and was planning to pursue an LLM in the United States. The Jessup competition was very much in Sarkhan's heart and soul. He assisted Ada University's first Jessup team in 2023, which qualified for the White and Case international rounds. This year, he was a member of the Ada team, which again won the Azerbaijani national rounds. That competition was held on March 3rd, the day which would have been Sarkhan's 22nd birthday. Let me ask you all please to rise and to join me in observing a moment of silence in memory of these two departed members of our Jessup family, Vednanda and Sarkhan Hasanov. Thank you. I now have the enormous privilege of expressing on behalf of ILSA and the Jessup competition our gratitude to a man who has defined the term friend of the Jessup. For 16 years, until his recent retirement from the position, Hugh Verrier was chair of the global law firm of White and Case. And during his entire tenure, he used that august platform not only to cement his firm's status as one of the premier law firms on earth, but at the same time to advance the study and practice of international law in significant ways. Hugh threw the weight of White and Case's support behind the Jessup, first as head of the firm's Moscow office in the early 2000s, sponsoring the Russian national rounds. But that was just the start. His interest has always been the promotion of international understanding and international law, and the Jessup provided him an ideal vehicle to pursue those goals. Thanks to Hugh, White and Case not only has been the preeminent financial backer of this competition, witness the banner behind me, but has encouraged the active participation of firm partners, associates, counsel, and staff in national and regional rounds around the world, and of course here at the White and Case international rounds. Hugh once spoke at this very annual occasion, and he said this about the value of what brings us together today. He said, quote, "The Jessup is an opportunity to broaden your horizons, to become part of an international community of lawyers, and to open up the world as you open up a world in yourself." Hugh was characteristically too modest to accept recognition for his contributions while he was in office. But now that he has stepped down as chair, we have managed to persuade him to join us today to accept an expression of ILSA's deep and abiding gratitude to our friend, our mentor, our role model, and a visionary. Hugh, would you come up and accept this? Now, finally, as tradition requires, I am now going to tell you the subject matters of the Jessup competition problem for 2025. What I am about to read to you will be on the ILSA website, and it is all you are going to know about the 2025 Statement of Agreed Facts until it is released in September, 5 months from now. So get ready. Here it is. The Jessup 2025 problem will present the following issues. Number one, the rights and obligations of other members of the international community when two people claim to be the legitimate president of a state. Number two, invocation of immunity for government officials accused of grave violations of human rights. Number three, the legal consequences of receding coastlines for the maritime zones of coastal states. And number four, the interpretation of the compromissory clause in a treaty creating a regional organization. That's it. We at ILSA right, you'll have 5 months to think about this. We at ILSA hope that what you have just seen in this final round and what you've experienced throughout this competition will continue to motivate you after the 2024 competition comes to a close. We welcome everyone here as part of this global Jessup family. And committed, all of you committed to the notion, despite everything that's going on in the world today, that the world is a better place if it is ruled by law and not by the whims of politics, if it respects human rights, and if it applies and abides by rules of law to which we have all had a hand in their creation. I want to add one personal note, which is this. Every year, this event, this final round, reminds me of the Jessup motto. I haven't heard it a lot yet. The Jessup motto, which is, in the future, world leaders will look at each other differently because they first met here as friends. The class of 2024, so to speak, has done it again. I am absolutely sure that the world leaders of the future are in this room or are watching online right now. And I am confident that as you assume those responsibilities, you will do so inspired by what you shared here, the spirit of this Jessup competition grounded in international law. And now some of you may have noticed I have just received a wave signal from the door. I am informed that the judges are ready to tell us what we all want to know and to announce which team will have its name engraved on the Jessup Cup over there as the world champions for 2024. Thanks for your attention. See you all next year.
All rise.
Please be seated. No, it's up to me only.
Yes.
Oh, very good. Well, thank you for your presence this evening. It is a great pleasure to announce now the awards and those who have succeeded in this very harsh competition. The first award is the Stephen M. Schwebel. Oh, this one.
Aren't we going to
sorry. The comments, yes. I always forget that. We have some comments before getting to the award. Yes?
To prolong.
Sorry. Sorry, because... you know, it's very difficult in my case to follow instructions. I always break them. Well, we have certain comments. We are going to start with my colleague to my right.
Oh, well, thank you very much. Well, if you allow me to start on a very personal notice, I have to confess, it's my first experience with Jessup, and my very first experience with such a lively communication with the parties. Having served for 12 years on the bench of the European Court of Human Rights, where we are not entitled to ask any questions until both parties finish their pleadings, and it takes an hour at minimum. And then actually they're pleading, they're reading their statements. So you might feel that I was physically suffering having to interrupt you, you know. So that is something, and really having now this experience, I realize how much we lost and still losing at the European Court, having this so strictly formalized proceedings where we cannot engage into real conversation. So I was really amazed with today's round. Guys, you are just brilliant. The depth of your knowledge, your culture, the way how you communicate, how you reacted to two questions, which again, in my view, the proceedings were still hostile for me, for my legal culture, and how you were able, you know, to proceed, to engage. And what I also admired is how fair you were to international law, both parties. You did not abuse, you did not misuse it, and this is, again, as we say in French, chapeau. Now, I assume today half of international lawyers all over the world are dismissed because international law companies are fighting behind the door, wanting to have you, to hire you. That's what I would do because you are really brilliant and you have a fantastic future. The only thing, if you allow me, what I lacked as a human rights judge is a reference to a human dignity in this particular case, because the right to nationality, although not sufficiently reflected in international treaties, is, according to Hannah Arendt, is a right to have, right? It's a starting point for international human rights law. But having said this, I understand that, of course, you dealt with international law, and you dealt with it brilliantly. You were very fair to international law, and my sincere admiration and my deep thanks for this afternoon, which I spent with you. Thank you very much.
Thank you, Judge. Would you like to say something, please?
Thank you. Thank you, Anna. I don't have very much to add. I just wanted to say that I really want to congratulate the authors of the problem, because I think they wrote a problem that lent itself to so many interesting dimensions. So I do congratulate the authors of the problem, but right now I want to congratulate the six of you because, as I said a few moments ago, I think the quality of the advocacy was simply of the most highest level imaginable. I think the three of us, as we were going through the scores, it was just a question of whether it was 1 or 2 marks off 100% rather than whether it was big differences, because the quality was just so high. I think each of you demonstrated the level of advocacy today that would have left my generation way behind. It was a long time ago, 38 years ago, but I don't recall in my time seeing the quality of advocacy that I saw today. And I think that's enormously encouraging. And speaking for myself, I preside over a court. I would be delighted to have any of you appear in my court, because I think you will acquit yourselves extremely well. So really mean that. I was struck not only by your complete mastery of the law and the facts, that was really flawless, but I do want to say one thing which I really enjoyed. I remember as a mooter at a practice round, one of my professors said to me, he gave me a piece of advice which I've kind of hung on to and I've tried to use over the years as an advocate. And he said, when you confront a bench, don't be aggressive, because they're not actually trying to make life difficult for you. They're grappling with the problem. And your job as counsel is to physically imagine that instead of standing in front of them, you're standing by their side, whispering into their ear to help them get to the right result. And I thought that was superb advice, because as an advocate, when I was a young advocate, I tended to be very, very aggressive, and I had to be reined in. And I thought it was very good advice, and it took me a lifetime of practice to try and make some progress in that direction. But I was struck by the fact that all four of you appeared before us today never gave me the impression that you were annoyed or felt that we were fighting with you. You took the questions perfectly in stride. You dealt with them very calmly. You even managed to smile at us when we asked you questions. And I was very impressed by that, because I think that's a mark of a mature advocate who understands that her role is really to help the bench. And when we say, if I may be of assistance, that's what we're really trying to do. We're trying to assist the court because we understand that the court's got this extremely difficult job, and it can't do it without the assistance of counsel. And I thought each of you embodied that spirit of being there to assist us very, very well. And on occasion, when we put to you propositions that you didn't agree with or couldn't accept, you pushed back very politely. You pushed back very politely, but made it clear that you were not going to take whatever we threw at you, which is, again, a mark of a good advocate. Because sometimes you have to disagree with what the bench is saying, and there's nothing wrong with that. It's how you go about doing it. And I thought that you exemplified that perfectly. The only other thing I wanted to say was that I guess it's a reflection of the fact that we've come to the final. But I do want to say this to all of you in the room. Coming to this stage is already an amazing achievement. And I do want to make the point that whilst we've seen the two best teams of this competition, if this is the standard, I'm hugely impressed and very hopeful for the future. So I congratulate all of you, and thank you for giving me the opportunity to be a part of the proceedings this afternoon.
Very good, thank you. Thank you very much. And just some concluding remarks, because you have already expressed the common views of the bench. You're aware that you have reached the highest position, not only in the competition, but also among different universities and in the world. And also the other teams that are present here have also reached a very high position in their countries and in the competition itself. I would like to express sincere congratulations. This is a very formal way to say, but I think you deserve this. You have been gratifying. You have given us a gratifying moment to share with you the possibility to not only to mark what you have been saying, but also to participate in this exchange of views. Not all of the questions were very positive in the sense that your country had to face very difficult and complex problems and arguments. And not all of the arguments were easy to follow or to approach. Maybe you had to forget certain values or certain positions or personal views on certain issues, and this is the value of this competition. You are going to deal with the representation of a state or of a very complex subject of international law with different interests and positions, and international law should be part of that decision-making process. That is the value, among others, of this competition. You have prepared yourselves for a long time, most probably for a year or even longer. You have gone through a process of selection and so on. Now it is the moment to look forward. The future is ahead. You will have a next stage, maybe as an academic or postgraduate studies, or professionally involved in advocacy. So continue with this very high spirit. It is a spirit of understanding, commitment, also responsibility, and taking a position which is based on law. So thank you very much for being present here and for your collaboration in this very difficult session, which is the final one. It was also difficult for the bench, I must say. And and now we're going to move towards the awarding or rewarding. Yes, first, it is the best oralist in the final round. It is an award that was established to honor the name of a famous jurist and also judge, Stephen M. Schwebel. This award is named in honor of Stephen Schwebel, who served as a judge of the International Court of Justice from 1981 to 2000, and in 1959, as an assistant professor of law at Harvard University, he established an international law moot court competition, which we recognize now, today, as the Philip C. Jessup International Law Moot Court Competition. So there is strong connection with Judge Schwebel. The recipient of this award as best oralist in the final round is Mr. Ignacio Villarreal. And the award is given to you. And now we move to the teams, which is very difficult to announce. Both teams were very impressive. You had very rich and comprehensive arguments, and it was difficult to decide which team had more scores or deserved more scores. So the differentiation was very tight. We had an applicant with Torcuato, Universidad Torcuato de Tella from Argentina, team 109. Now we disclose it is you. And respondent, University of the Philippines, team 785. That's you. Now the moment has come to announce the winner of the White and Case Jessup World Championship. The winner is the respondent team.